So today we are bringing one of our enlightening topics like we always do. And the focus of today's topic is on the legal framework or the legal foundation on debt recovery generally. So okay, the topic is legal framework on debt recovery, obviously in Nigeria. So before I move further, there's this clarification I would like to make. So I wouldn't call it a misconception. However, there is this impromptu or initial thought that comes to everyone's mind where you hear the word debt. Ordinarily, yes, it means money being owed by a person known as a debtor to another person known as a creditor. However, that's the instance through which that debt arose don't necessarily mean that the creditor borrowed the debtor the money. Let me get back again. Like I said, debt simply means money being owed by one person to another person. And the general idea when debt arises is that one borrowed money to another person, and the person that the money was being borrowed to could not pay it. Therefore, the debt has arisen. However, that is not always the case. So I'm going to read out a definition on the word debt given in the case of NIPOST and Insight Engineering Company Limited. This is what the court had to say in terms of what a debt is. Permit me to read directly so I wouldn't mix the words. As a result, for a money claim to be considered a debt, the money must be a specific sum, a specific fixed or liquidated amount of money. There must be a due date when that money is to be repaid or to be given out. Okay, let me just read it as it says here. As a result, for a money claim to be considered a debt, the money must be a specific sum, a specific fixed or liquidated amount of money. There must be a due date, and such due date must have passed, and it must arise from some agreement between parties to it, known as the debtor, that is the person who owes the debt, and the creditor, a person who claims or is entitled to recovery. So looking at this definition, what we should pick out of is that debt must be specific, fixed, and liquidated. It simply means that when you hear liquidated, it simply means that that amount can be derived from some form of mathematical equation. It simply means you can identify the specific amounts leading up to the general debt, or you can easily pick out from first instance why that money is so. Maybe we entered into a business where I'm to supply 200 grams of sugar, and the other person is to pay the sum of 100,000 naira for it. And then I've supplied the sugar and the other person has failed to pay me. At that point in time, it is liquidated because you can easily tell that, okay, this 100,000 naira is for these 200 grams of sugar. Maybe it was 10 naira per gram or whatever, but you get the idea. So my point here is, whenever you hear the word debt, your mind shouldn't just go to party A, borrowed money from party B, and can't pay back party A. No, that's not the case. Debt generally means money owed from whatever, because even in it says here that it must arise from some agreement between the parties. It did not say that it must arise from a loan agreement, because whenever I hear the word agreements, just know that the words agreements and contracts are they're synonymous to each other. It simply means two people, having a consensus added them. This is what they want to do, and they go about it. So it did not say it must arise from a loan agreement. It simply said an agreement. So where two parties, or as many parties as possible, are involved in a contract or some form of business arrangement, where Party A is to supply either goods or service at specific rates, and the goods or service was provided, and the other party failed to pay the money accruing from the goods or services provided. At that instance, obviously, with this example I gave now, nobody borrowed money from anybody. These were two businessmen who came together to, do business, to engage themselves financially, meaningfully, to develop for whatever reason. And then at some point there was some form of, maybe at a party failed to perform a part of the contract. Obviously, at that instance, where so far as money is involved, and that money is liquidated. In other words, you can, on your own, by reading the facts accruing to the case, you can simply read and identify the rates or the points at which this money is coming from. And that is what that debt is. So please, this is important just to clear the misconception that whenever you hear the word debt, you're only talking about money being borrowed. No. Debt is money being owed. It doesn't have to be from borrowing. It could simply be from contract, even generally from contract. Even a loan agreement is a form of contract. So having clarified that, let's forge ahead. Like I said, the topic is legal framework of debt recovery in Nigeria. Legal framework of debt recovery in Nigeria. So the idea is, from all the conversations, for those of you that have been following or the conversations we've had on how to recover debts, there are two broad classes of recovering debt, broad ways rather, of recovering debts. The first way is through ADR, alternative dispute resolution, and the other way is through litigation. So what we are going to do here now, or rather we're already doing it, so what we would further show are the laws that govern these two major modes of debt recovery. So on the part of, let's start with litigation, or ADR instead. On the part of ADR, we have the Arbitration and Conciliation Act in Nigeria. Now, the fun part of ADR is this. You may not necessarily even need to involve yourself with any particular law or legislation. We all know the forms of ADR that exist: mediation, negotiation, arbitration. Now, for mediation and negotiation, you may not necessarily have to consider any law. This is simply you trying to reach a gentleman agreement with the debtor, or the debtor reaching out to the creditor, as the case may be. However, when you take further steps to involving arbitration or conciliation, then at that point you would have to consider the Arbitration and Conciliation Act, in addition to any other ADR rules that may be applicable within the jurisdiction at hand. So that's basically it for ADR. That's very simple. Now, for the litigation aspect, when it comes to debt, reference should be made to the Limitation Act. Now, obvious from the name Limitation Act, that's a federal legislation applying throughout Nigeria. However, the point you have to make is, there's going to be, most of our federal laws usually have they are usually further domiciled into the various states, and you have similar provisions. For example, now we are in Lagos now, or rather I'm in Lagos. I don't know about you, but I'm in Lagos now. So the law in Lagos, it's known as the Limitation of Action Law of Lagos State. Now, with reference to that, the section here is section 21, section 21, subsection 1, paragraph A. And it simply provides that, let me read it out. The statute of limitation for debt collection deriving from a simple contract is 6 years from the date the contract was entered into and executed, except the year the contract was entered into and executed. So everything I just read here is that so far as you want to recover debt from a debtor, you have 6 years to do so. And the 6 years starts counting from the next year. For instance, let's say the debt arose in what month is this? We're in May. The debt arose 5th May 2023. The statute of limitation, or rather the period in which, that's the 6-year period in which you are to take recovery steps to get back your money, starts counting from next year. That's what I read here, that from a simple contract is 6 years from the date the contract was entered into, except that you are going to remove that year that the contract or whatever agreement was entered into. Basically, the agreement from which the debt arose, you are going to minus that year. So far as debt is debt in whatever form, the law does not specify debt from loan agreement, debt from business transaction, debt from personal borrowing, whatever. So far as it is a debt under the definition of the word debt, in the case of NIPOST and Insight Engineering Company Limited, like I gave earlier, you have 6 years to take all necessary and lawful steps to recover the money. Now, reading that law alone, it only tells you the time frame within which you are to initiate recovery process against the debtor. So I took the further step of showing how you can do it. This limitation of action law of Lagos State shows you what to do. So the next part we are going to proceed into now is going to show you how you are going to do it. So the next part is, all the laws I'm going to mention now are the laws that deal with how. So when you're looking at procedure in any procedure when it comes to the courts, you always have to look out for the court rules within your jurisdiction. Again, we are in Lagos, and let's say we are dealing with the High Court. So reference in this case is made to the High Court Civil Procedure Rules of Lagos State 2019. So one of the modes through which one can initiate a debt recovery process against another person, as against the debtor, is known as summary judgment procedure under Order 11. Sorry, under Order 13, not 11. Order 13 of the Lagos State Civil Procedure Rules. And then if it's Abuja, that's Order 11 of the High Court Civil Procedure Rules of the Federal Capital Territory, Abuja, 2018. So whenever I hear the word summary judgment, the idea is because it's an application, you have to make the application to the court. So the idea is that you are telling the court that, look, yes, there is a matter at hand, there is a case at hand. However, the person who I am initiating this action against has no good defense to the matter at hand. So there's no point going through the full rudiments of trial. So the idea, and the reason, obviously, you don't just come and make such assertions without more. So the best way to do this is, when in making your application, you have to depose to these facts in what is known as the affidavit. Every application before the court is done by way of motion, and it is supported by another court process known as an affidavit. And this affidavit is where you make all depositions of your facts. This is basically where you are stating the reasons, the factual reasons. You're not talking about law yet, just normal statements. Oh, this application is because this person did this person did that. So on that affidavit, that is where you are going to let the court know why you think that the debtor has no good defense, has no just cause at all in the summary judgment application you've made. And then what follows next is the written address, where you make your legal argument in support of your application. So that's the idea of summary judgment. So mind you, because you have made a summary judgment application against the debtor, does not necessarily mean that that's where it ends. The debtor still has an opportunity to obviously give a counter to that application for summary judgment, telling the court that, my lord, yes, the applicant has said this, but however, I have a good defense as to why this summary judgment should not be entered in favor of the applicant and why the matter should go into trial for it to be held on its merit. So the moment that is done and the court considers the application and the counter affidavit to that application, if the ruling is that from the counter affidavit and written address of the respondent that there shouldn't be, that there is a good defense to the matter at hand, therefore it should go into trial, fine. The matter goes into trial. However, where the court rules in favor of the applicant, in this case the creditor, then the relief sought in the application for summary judgment moves on. The court will hold the ruling in favor, and that forms the judgment of that matter. So, like I said, summary judgment, the idea is the debtor has no good defense for failing to pay the debt. So the next procedure that can be adopted is known as the undefended list procedure. Now, this does not apply in Lagos. At least the High Court rules of Lagos currently gives no provision for undefended list. So this is a procedure that may be obtainable in any other state in Nigeria aside Lagos. For example, in Abuja, Order 35. This is also, Order 35 of the High Court Civil Procedure Rules of Abuja. So this is also similar with undefended list. The idea here again is the defendant, or rather, the person against whom the application is made, in this case being the debtor. Well, I hope you understand that so far as it's going to court is concerned, the debtor, it is very rare to see a debtor taking a creditor to court, except where the creditor, in trying to recover his money, the debt, has gone contrary to the law or at some point infringed the rights of the debtor or did something contrary to law. So yes, in that instance, the debtor can bring can file any suit in whatever it may be against the creditor. However, so far as it has to do with recovering debt, obviously the creditor is the one who is filing the suit against the debtor. So this summary judgment procedure analysis I gave, it's obviously the creditor who is the one making the application against the debtor. And also under this undefended list, again, the creditor initiating the application against the debtor. Now, the other mode that this can be brought under is what is popularly known as the writ of summons. Yeah, writ of summons is one of the most basic mode of commencement of action in court. So, and it's usually for contentious issues. By contentious issues, I mean where it is clear that both parties are, saying that they are in their rights. So the best mode to bring in such application would definitely be via writ of summons. And this usually arises in cases in business agreements. That's any agreement other than loan agreements. Now, this is me just talking. And the reason I'm saying this is because in a loan agreement, obviously, money was dispersed. The time within which the money is to be paid has passed. So therefore, the money, the creditor wants to recover the money back. So that one is clear. It's usually very clear. However, in a business arrangement where party A was to supply goods to party B, and party B is to pay for the goods, party A supplied the goods, and then it's left for party B to send the money. The issue could be that it's not that party B doesn't want to pay the money, but the goods supply did not meet the requirements, or upon transition, it got damaged. So party B is saying, you supplied damaged goods, I shouldn't be the one to pay for it. Party A is saying, I supplied it now. Maybe it got to your warehouse, nobody was there to receive the goods, and you had to wait outside and rain fell on it, and things like that. So these are, when you hear contentious issues, just basically both sides telling their own stories. Oh, this is what happened. Oh, this is another thing that happened. So where this arises, the best mode of commencement is with writ of summons. Now, the modes I just mentioned here apply to the high courts. So aside the high courts, one can also commence action at the magistrate court under summary summons procedure, under Order 3, summary summons for a debt of liquidated money demand and breach under Order 2. Okay, breach of summons under Order 3 of the ordinary summons. The truth is that you would need the involvement or the consultation of a legal practitioner to fully understand what I am saying here if you are not in the line of the profession. So, but basically this is the idea behind the law. So just to reiterate, the first law I mentioned was the Arbitration and Conciliation Act when it involves ADR, specifically arbitration and conciliation. The next law I mentioned is the Limitation of Action Law of Lagos State, specifically Section 21, subsection 1A, that gives 6 years as the time frame within which one must initiate action to recover debt from another. In other words, if this time elapses and you have not initiated that action, you can't bring it up anymore. It will be known as what is called statute barred. So the next law I mentioned is the High Court Civil Procedure Rules of Lagos State 2019 for procedures like the summary judgment procedure, undefended list, and then the writ of summons, because these are procedures, are recognized by by the High Court rules. You cannot commence any action outside the High Court rules or outside any rules that is applicable, any applicable rule. So I also mentioned the High Court Civil Procedure Rules of the Federal Capital Territory, Abuja 2018. And now the other one I just mentioned now is the Magistrate Courts Law, or the 2009. I stand corrected, or the Magistrate Court Civil Procedure Rules. So these, and under the Magistrate Courts, the procedure is Order 3 summary summons for a debt of liquidated money demand or breach of summons order under 3 ordinary summons. So that's about it. But just for the sake of generality, I'm going to mention the general mode of commencement. So ordinarily, where debt arises, the first thing to be done is to reach out to the person owing this debt. In other words, amicable settlement. Most agreements allow for this, be it loan agreements, be it a normal business contract, whatever. Usually, there's always a clause known as disputes clause, settlement clause, call it whatever you want, where it is provided that where any dispute arises from this agreement, that parties would resort to amicable settlement first. If amicable settlement does not work, then parties can approach so, and things like that. It's basically what both parties agree to. So if that procedure does not work, the next thing to do would be for the creditor or whoever the money is being owed, yes, the creditor, to issue what is known as a letter of demand. In some instances, the law provides for what is known as statutory letter of demand. That's the one basically provided for by the law. However, so far as money is involved, letter of demand is usually like the normal thing to do. So you issue what is known as a letter of demand, briefly giving a history of the transaction that transpired so far and why this money must be paid and the time frame within which it should be paid. Now, after a time frame has been given and no favorable response was given, the next thing to do is to issue what is known as a pre-action notice. Now, the difference with a letter of demand is simply you asking for the money being owed to you, asking for compensation generally. However, a pre-action notice goes further to let you know that if this, I'm talking too much. A pre-action notice is simply telling the other party that we will soon be going to court or that we are going to court. We issued you a letter of demand. You made no necessary steps to pay or settle the debt. Therefore, we are going to court to sort it out. Again, time frame is given within which the other person is to reply. Now, where the other party fails to reply to your pre-action notice, it can be assumed that the person is ready to go to court. On that instance, you cannot initiate any of the procedures I just mentioned, summary judgment, undefended list, or through writ of summons to recover your debt. So that is it for now. Thank you so much. I'm sorry I took so much of your time, but I'm sure that you got value for your time and for your audience. Thank you so much. I remain your